after this, so we'll go ahead and call this meeting to order. Senator Bearden, would you please open us up in prayer? What number are you? Number 11. All right.
Lord, I ask you that you just keep us safe today as we go into this late hour, and for those that's leaving home, to keep them safe on their travels. Let us do the right things for the citizens of this state, and also never let us forget the reason why the Lord was sent here to this world was to forgive this world and not to condemn it. In Christ's name I pray. Amen.
All right, so this will be a first meeting of the Senate Judiciary Subcommittee. We have two items on the agenda today, Senate Bill 398 and Senate Bill 405. For those that are here, just to give you a brief rundown of what we're going to do, we won't take action on either bill today. We'll hear testimony. I see Senator Setzler's here, so I'm going to go ahead and let you go first. Present the bill, we'll hear testimony, and then based on the testimony, if we want to do, if you want to do a substitute, or we may just go ahead and get a favorable recommendation to the full committee. But you want to go ahead and come up and do Senate Bill 405?
Mr. Chairman, members of the subcommittee, I appreciate your time very much. I bring before you today Senate Bill 405, a bill that does a very simple thing. It raises the maximum threshold for a case in magistrate court from $15,000 to $50,000. The existing threshold was put in place in the 1998 session 28 years ago. The threshold before had been $5,000. The threshold then became $15,000. The thinking here being, when the threshold jumped last time, you don't just move it a little bit, you make a big jump in it. And the thinking all along is really, when we think about civil justice, there was a lot of talk last session about tort reform, and how do we provide access to justice for people. One thing that's very important to me, Mr. Chairman and members of the committee, is the idea of what I call small justice, not these big nuclear verdicts, not on these massive questions, but on the cases of regular citizens that have a dispute amongst each other. Being able to bring a case in small claims court with simplified process, no requirement to have an attorney to represent you. You're not tripped up by procedural missteps as you could in a state court. It's a much more streamlined process, but it does allow, it's a fact-based, more fact-focused system where judges can make fact-based determinations. The thinking here is $50,000 is the cost of the average automobile now. This is not relating to automobile accidents, but an automobile scale claim. You think about property people own. If something's a car in value or less, that in my mind is kind of what you think about in a small claims court. If it's larger than that, lowering up to take on a case is probably the reality. My thinking here, Mr. Chairman, is in the realities of our current system, if a citizen has to engage counsel, has to hire an attorney for $10,000 or $12,000 to defend a claim that's a $35,000 or $40,000 or $45,000 claim, it's just it's overwhelming for citizens. They can't produce the retainer to hire an attorney to get them into state court to be able to file a claim. And I think in my mind, there are obviously procedural ways, if there's discovery and those kind of things involved, that can certainly move straight to state court. But for simple, fact-specific cases, it's my belief that we should not set a threshold lower than $50,000, because in many cases claims are very simple, and we shouldn't set an artificially low threshold. And I believe 50s, even though it's the same scale jump we saw in 1999, we went from 5,000 to 15,000, is a 3x jump. That's about what we're doing here, but it's consistent about with the price of the average automobile. Mr. Chairman, glad to take questions.
All right. Does anyone have any questions for the author? We got one. Senator Bearden.
Appreciate you bringing this forward. Any idea how this would affect our magistrate courts? I mean, caseload, because when you usually go in now, it's pretty crowded.
Caseload's going to increase. I mean, it's certainly, if you're making a change like this to the threshold, I think the question is, where do we put our resources and where are resources most effectively employed? In my view, the ability to take advantage of the efficiencies of magistrate court, the ability to get citizens to be able to get to a ruling in a more streamlined way. The justice value, again, I might use the term small justice, warrants that. More resources in the overall judicial pie will flow to magistrate courts versus state courts, in as much as the caseload's going to move that way. But I think it's a more efficient delivery system, and it's certainly more efficient for the citizens who are involved in disputes.
One more question, Chairman. And it may be a different committee, but if the minimum liability policy has now increased 25,000, do you think we should bump that up to 50,000 as well?
Well, I saw the remarks. I reject the premise that the automobile insurance threshold is somehow tied to this bill. That might have been incidental. Someone might be making that argument. I don't think the two are linked. That certainly was not part of my calculation. I will tell you personally, although this is not this bill, if the average automobile is $50,000, I believe the threshold ought to be higher than $25,000. I'm not going to try to wade into that swamp in this bill. I think if you look at those numbers over time, perhaps we're not exactly where we need to be there. But for the purposes of simplified dispute resolution, I think it's just principally wrong for a transaction cost of both sides possibly having to engage counsel. Not that you can't be pro se in state court, but it's a different level game. I just think the transaction cost for us citizens of having to engage counsel to get into court to fight out a $35,000 or $45,000 case, if it's very simple in the facts, it's really talking about a tax on our citizens. That's really the cost I'm most concerned about.
Appreciate it.
And I have a question, and this is more for those who are watching. Decision from magistrate court is immediately appealable to a superior court. Is that correct?
Correct.
All right. Any other questions? If not, we have one person to sign up, Bob Bray.
Good afternoon, everybody. Thank you. I am Bob Bray. I am the Executive Director for the Council of State Court Judges, and I think we sent each of you a statement of our position. It should be in your packet. We don't necessarily oppose the bill in looking for an increase, but I think most of our judges are a little flummoxed as to what you might call a small claim. So Senator Setzler sets it at $50,000 or the price of a new car. When I bought my first house in Cobb County in '79, it was $50,000. That was not a small claim. I bought a car about 8 months ago, a new car. It was $50,000. To me, that's not a small claim. And I was talking to him. I went to Furman University. I was looking at tuition. There, 1.5 year tuition there at Furman is $42,000. That's not a small amount. So, I think what we were looking at is probably a way to come up with a rational and practical way to figure out what a small claim might be, because this is the People's Court. The Civil Procedure Act isn't really followed in these particular courts. People can come up with a document and show it to the judge. So we felt like maybe the limits of an automobile insurance policy, which is now $25,000, might be a good premise to base it on. Let me add, too, that of the 520 magistrate court judges, the ones in metro areas are probably lawyers, but for the vast majority of magistrate court judges, they are not lawyer judges. Many of the counties have a person who owns the flower shop. They may be the parts manager at an auto dealership or own a pizza restaurant. Those are the people now that you want to put over these types of cases that have dispositions of $50,000. That's a significant impact on people and families now. In 2024, which is the last number I have, recent number, in state courts statewide, there were 600 appeals filed by from magistrate court to state court. To answer your question, Senator Hatchett, the state court can also receive appeals from the magistrate court.
And could you repeat that number again, the number of appeals that were received?
Statewide, 600.
600? Okay.
Mhm. If you treble that limit now to $50,000, I don't think it takes a rocket scientist to figure out you're going to have a whole lot more appeals coming from the magistrate court to the state courts and the superior courts. But anyway, we thought that we understand it's probably time for a change, but for small claims, we felt like a good basis would be the $25,000.
Okay, you have a couple questions. Chairman Watson?
Thank you, Mr. Chairman. You said how many appeals went to Superior Court or State Court?
The 600 went to state court.
600 out of how many?
I have no idea. I have no idea how many people don't appeal their cases.
Well, I
It's
mean,
just that
yeah.
these are the
I mean,
ones that are
to me, that
reported.
sounds like a really small number.
Well, I don't know. I don't know how many appeal. I don't know how many go.
Okay.
But
All right.
we just started tracking those numbers, and it has increased each year. So it's 600 now.
It's a relatively insignificant number.
Yeah,
of
but when you
appeals.
get to $50,000,
So you're telling me 15,000 up to 15,000, so not many are appealed. So all the everything now 15,000 above is going to state or superior court then.
anything above 15,000,
Is that right? I mean,
it's anything below.
everybody says
15,000.
yes. Okay.
Yeah.
All right.
All right, thank you, Chairman Watson. Chairman Tillery?
Thank you, Chairman Hatchett. Honored to be at your first hearing. Bob, thanks for the comment. I just want to play devil's advocate with the numbers a little bit with you a little
Sure.
bit. Do you think also though that there are cases now that have to go to state and superior court that possibly could get resolved now at magistrate court? Just playing devil's advocate with the numbers a little bit. What would you concede that point to me, maybe?
Well, sure. I mean, that's always a possibility. I mean, you could set it at 100,000, and that's going to be the same fact,
Right.
right? But if it's the people's court and it's supposed to provide access for small claims, where people can introduce a document to the judge and the judge can just look at it, which doesn't happen in the other courts. Also, we got jury trials too.
I'm telling you, I've had some interesting times in magistrate court. It's
Okay,
very interesting times that
All
would
I bet.
just be interesting. But so I hear your point, and I think it's very valid. I'm leaning the other way though, just because it has been so long since we've upped it, and it's probably going to be a long time till we do it again. And based on that, I'm wondering, without some automatic escalator, which I don't know that we could think of, just sort of leaning that way. But please know that that's nothing against the magistrate court counselor. Your testimony at all. I mean, you are very well regarded in this building.
Thank you very much. Appreciate that. Thank you, sir.
Thank you. Is it Senator Parent?
Yeah.
Okay.
Hi.
Thank you, Bob. So part of me agrees with Senator Tillery's point that we rarely raise it. And in thinking this through, where I currently am is I would like the number to be as high as it could possibly be without compromising the efficiency and the ability for individuals to kind of handle it on their own with limited resources. And that means there can't be too much paperwork. It can't get too complex. And I don't really know what that number is. And it seems like we're not trying to really figure it out. Do we have anyone, do we have anyone who could fill me in a little bit more about, obviously it's imperfect, but where is that right now where we have to make the judgment call? I understand, but
You bring up a good point.
where is that
Senator
level right
Parent.
now in today's dollars?
Typically what happens is the Council of Magistrate Court Judges, or if it was us, the Council of State Court, would bring this legislative change request to the Judicial Council Legislative Committee, and then it would get discussed by all the classes of court. And it could get into some of those deep details of what might that number be, or what would a good cutoff number be. But because this was introduced without it's not coming from the Council of Magistrate Court Judges, it never got that process. So that was one of the things we put in our statement was typically this you would think this might go before the Judicial Council, that the judicial branch examine it and get that information, which would be free to you, and then you can make those decisions of how to change that jurisdiction if you needed to. Does that answer your question?
Sort of, yes.
Okay.
Yes, I mean, certainly as well as you could. Has input been delivered by the magistrate court judges who most regularly hear these?
No. We got a letter from their president this morning that they're taking a neutral position on this particular bill.
Okay, thank you.
Okay.
All right. You have no further questions. Thank you.
Thank you all very much.
Yeah. Senator Setzler, like I said at the beginning, we're not going to actually take action on this bill today. I've spoken with Chairman Strickland, and what we'll do is we'll make a recommendation to his full committee.
Okay.
But wanted to give you the opportunity if you wanted to address any of the issues that were brought up previously, or you can just sit down. Either
Sure.
way.
Appreciate it, Mr. Chairman. Just, I guess, in summary, the crux of this is access to justice. I've got constituent after constituent after constituent that has a small claim issue. They can't scrub together $5,000 to get an attorney to help them do things. And that's kind of your minimum level retainer to get an attorney, and it's probably going to be $10,000 or $12,000 if it has any real dispute to it. That's the reality of legal counsel today. I think when you look at the scale of cases, if someone comes in and trashes a rental house of yours, and you're trying to just kind of work that out. That could easily be a $25,000 or $30,000 claim, depending on what happens. This is not a car insurance thing, but you think about what is the value of the property that normal people walking around, working class people deal with every day. Unfortunately, it's a $50,000 car, and my thinking was, what's a car value in less? And if the judge feels like there's a need to go deeper because a document he or she are looking at doesn't feel right. There's another process to kick that up to. I just feel like there's enough cases that are fact specific enough that when we set a threshold that it can never go above a certain threshold, this is like the statutory maximum, I feel like that ought to be set a little bit higher than probably where it's going to be needed every day. So as a matter of course, we're talking $25,000 to $35,000 to $40,000 cases. Statutory max at 50. And as Senator Tillery said, we went from 5 to 15, so we tripled it last time. My thinking was that's about what this does. It's no more than that, but it really gets back to that issue of at what point should you have to come up with thousands of dollars to represent yourself, and most folks can't do that today. And in magistrate court, if you are right on an issue, you can win on the merits. I don't think we should keep you from court if someone does something that's $35,000 or $40,000 in scale. That's it.
Thank you. All right. Well, we'll report to Senator Strickland, and he'll call you for the full committee for a further hearing. But thank you for bringing this bill to us.
Thank you, Mr. Chair, members of the committee.
All right. So the next item on the agenda is Senate Bill 398, which is a bill that I'm carrying. Senator Tillery, would you mind taking over while I go present? Now you have your chance.
All right, Senator Hatchett, if you don't mind just telling me the LC number so I can make sure we're all on the same page.
So we have LC 492505.
And do you have any committee substitutes or anything that you're going to be bringing here today?
I do not.
Any other amendments?
Not yet.
Okay. Go ahead.
Well,
We got a time limit on you, just 5 minutes.
5 minutes.
But go ahead. And if
See
you
what-
see me reach for my phone, that's why.
Gotcha. Well, thank you to the members of the committee for hearing this today. 10 years ago, 5 years ago, this probably this type of bill would be thought of as something in science fiction. Unfortunately, it's something that we are seeing every single day across the country, across the state. As a father of 4 daughters, what this aims to prevent is something that's somewhat of a nightmare. Right now, there are apps that use artificial intelligence that can take a photograph of anyone and undress them and make them do pretty much whatever you can imagine. To me, it's a huge invasion of privacy. It is being used to bully. And I don't think there's any place for not this technology, but this use of this technology in our society. I understand artificial intelligence is coming, and there's a lot of really good things that can come out of artificial intelligence, but there's also a lot of bad. And our criminal code wasn't necessarily written to keep up with the pace of technology. And so what this bill aims to do is essentially make it a criminal offense to use a photograph of someone without their consent, put it into an artificial intelligence type platform or app or any medium of that, and create these types of images. Now, once I drop this bill, I have been approached by several groups, and honestly, I'm very encouraged from the spectrum of people that are interested in this piece of legislation, and we've had some very good conversations. So for those that are here to testify for or against, I don't think there's anyone that's necessarily against the policy, which is what I'm focused on, but the bill as drafted is a little bit too broad. Some examples that have been brought up to me right now, if it was Senator Tillery's birthday party and I made a AI image of him for a birthday invitation, technically that would be a misdemeanor because he wouldn't know it was his surprise birthday party. So in these conversations, what I am planning on doing is, if you have a copy of the bill, essentially section B, which starts at line 39, I'll strike that from line 39 to 45. Section D, which starts at line 55, I'll strike that all the way through line 77. We'll have to do a little bit of cleanup, but essentially I'm going to remove the provisions that have to deal with just general use of the AI images, and we'll focus more on the sexually explicit, I'm going to call it what it is, child pornography in general of individuals, because that's really the core policy that I want. And I know there's going to be some more cleanup. So when we hear testimony today, I just wanted to go ahead and put that out there, that I am going to remove those sections, and then hopefully through the testimony today and working with the interested groups can come up with a substitute that will accomplish really the policy, which is you shouldn't have to be afraid to post an image of yourself online. You shouldn't be afraid to have a picture of yourself in a yearbook and have that photograph used in the ways that people are using them now. And there needs to be some protections in the law, and I think they need to be harsh punishments. I do think it needs to be a felony, especially when it comes to a child. I think it's a huge violation of privacy, and I look forward to working with the members of the committee and the members in the audience that have an interest in this. I'm happy to yield to any questions.
You do have a couple of questions. Senator Parent.
Senator Jones.
Jones.
Thank you so much, and I appreciate you bringing this legislation, because I actually think this is what we ought to be doing our time with, because technology is getting beyond our criminal justice system, quite frankly. But I do have a question. I like the fact that you're going to strike those two lines, but I still have a question on page 3, the lines 46 through 51, I think, because it seems like we are talking about obscene material, but two things. Number one, it still is adult, but then number two, it also seems like we're talking about possession only. So is there a difference now? Because the law, of course, would allow you to possess it, but there are, and this would be for anybody who's also going to testify, I do see a little bit of a difference, because normally if you're possession of obscene material, the other person maybe has consented to be in that obscene kind of situation possibly. This would not be that kind of consent, so that's a little bit different. But how do you kind of rectify the fact that under current law, you can possess obscene material of adult, but you can't distribute it? This looks like possession only.
Yeah, so the policy, and I'm glad you brought this up and would like to work with you on this. I guess the policy here is the creation. Obviously, if you're going to put this into an app and create it, I want to punish that person pretty heavily. Now, if you're that person and you share it, and then someone else possesses it, I think the penalties between an adult and a minor need to be different. But, really the creation or telling artificial intelligence to create it is the harsh penalty that I'm aiming to achieve. And then the possession would be a lesser offense, which is not represented in this piece of legislation yet, but will hopefully be in the substitute after we work those out.
So your intent on this would be, if you create it without any distribution, that would still be a crime?
Correct.
Okay.
Because
As long as
I
understand
just,
that.
from a policy perspective, I think that's a huge invasion of privacy to take someone's photo and undress them. I think there's a level of privacy that we need in our society, and that crosses the line.
All right, thank you.
You have no other questions from the committee? Senator Parent.
Later rising question. Thank you, Chairman Tillery. Thank you so much, Senator Hatchett. Okay, so this contemplates, just making sure I'm correct about this, that it's all real people.
Correct.
Okay. And can you just speak a little bit about the elimination of the fine for immediate family members?
Which line was that? I'm
Well,
sorry.
50, it's in here several times. Each time was a felony, I think. You had like line 84. Yeah. And it's on 54, but I think that may be.
That's one of the ones he struck. 80.
Right, I thought that one got
82.
struck, but the other one I don't believe did. 84.
Yeah, I
35.
think, and I may have to lean on Ledge Counsel for this one, because that was actually something that we discussed, and does it have something to do with the family purpose doctrine in civil suits, or just monetary fines from a family perspective? Or
I think the idea was that it would be an indirect penalty on the victim. If a victim's family member had to pay that penalty, that would just
That's
indirectly negatively impact the victim.
Can I follow up on that and ask, a spouse is an immediate family member, right?
Yes.
What if we were in a situation, because I could see it happening, where there was an estranged couple? It might even be more likely that there might be a scenario with sort of
Right.
obscene images with an estranged couple. So that's kind of what was going through my head.
Well, I think the policy there would be, if you are an estranged couple and you were to create this without the consent of your estranged spouse, in my opinion, civil penalties should still apply. But as far as the fine itself, if you're still married technically, like Michael was saying, it could negatively impact.
Yeah, and I get that we can't think of every scenario, but
Right.
that one seemed kind of obvious, so just wanted to raise it. Thank you.
No more questions from the committee. Is there anything else you'd like to add before we call the witnesses?
That's it.
Have a couple of witnesses who have signed up. Thank you, Chairman Hatchett. Kendrick Holder from the ACLU of Georgia.
Good afternoon, Chairman, members of the committee. My name is Kendrick Holder. I am a legislative fellow with the ACLU of Georgia, an organization that enhances and defends the First Amendment right of all Georgians. And I'm here testifying in opposition of Senate Bill 398. SB 398 does two very different things, and it's critical to separate them. First, the bill targets non-consensual, sexually explicit AI-generated images. And let me be very clear. The harms caused by the images are real, very serious, and are growing across the United States. At the same time, we do have concerns about subsection B of this bill, pages 1 and 2, lines 39 through 45, and subsection D of this bill, lines 55 through 64, that would criminalize the production and possession of non-obscene images, even when there is no distribution or proof of harm. Under this overly broad language, a person could face criminal penalties simply for generating an image, including satire, political commentary, artistic expression, parody, and other content that's protected by the First Amendment. This approach is far more expansive than other states' deepfake laws, such as Louisiana, Iowa, and South Dakota, which are limited to sexually explicit content alone. We've seen in other states what happens when legislators adopt overly broad approaches to regulating deepfakes. In Arizona, for example, the governor vetoed a similar bill over concerns that it would criminalize protected speech. Any solution must be narrowly tailored to the harm at issue, and SB 398 fails that test. As written, this bill is overly broad and risks criminalizing protected speech. For those reasons, we urge the committee to reject the bill as written. Thank you for your time, and I yield for questions.
Any questions from the committee? One.
Yes, sir.
Clearly, the ACLU would not support deep fake child porn.
No, sir.
So where do you draw your line? What rule would you suggest to us?
So the amended language that we have written would make it very specific to obscene images to create the narrowly tailored solution that we're looking for.
Do you have that language?
Yes, sir, we do. And we do have one-pagers as well that covers the issue areas along with the talking points, I believe, that was sent out.
Do you have that already, Chairman Hatchett?
If not, we can.
There one language? Okay, gotcha. Don't think we have that. Yeah. Gotcha. I've got your one pager. I just didn't see what language you suggested. Right.
Yeah.
Thank you. Senator Parent, do you have a question?
I do.
Okay.
But only if you're done, Mr. Chairman.
Yes, ma'am. That's all.
Thank you so much. So looking at your one pager, and thank you for being here and for your testimony. It seems that some of the initial amendments proposed by the author would address a big chunk of the concerns, obviously by focusing more on sexually explicit and pornographic pictures. But is it the case that distribution and proof of harm, that you believe that those also need to be requirements to the extent that they are not for criminal liability in the proposal?
So we do believe that the image creation in itself is a crime.
Okay.
And that the language regarding the distribution or proof should be tailored specifically to that offense.
Yeah, we got a little confused. So if the creation is a crime, then there wouldn't be necessarily the second half, right? So
Right.
I would seek some clarity around, in terms of the constitutionality that your organization is speaking to, and or best practices from other states, whatever you'd like to offer to the committee, in your talking points here about distribution and proof of harm for criminal liability. Just curious about the sort of specifics of that input. Thank you.
I think what Senator Parent's telling you is you're going to get into the old law school debate of defining obscenity.
Right.
And I think Chairman Hatchett's made a really good attempt at that. So I look forward to hearing what ways you can make that be more narrowly tailored.
Yes, sir.
There's no more questions for you. Thank you for being here, Mr. Holder.
Thank you all.
I think it's Ms. James from Georgia Now.
Thank Thank you all so much for having me. And it's good to see you all here. Especially good to see my senator, Senator Bilden. I live in your district. Hint, hint. You're my senator in my district, District 30. But thank you all so much for bringing this bill. I'm kind of in the middle. Again, I'm Triana Arnold James. I'm the president of Georgia National Organization for Women. And I just want to share with you, as someone who travels often and stay in hotel, virtual peeping is the part that I got from the bill. Feels wrong because it ignores the realities of life on the road. When you're constantly moving, hotel Wi-Fi, shared networks, and unfamiliar devices already create privacy risk. Adding a virtual peeping on top of that invites unnecessary exposure of personal data, conversation, and behavior in spaces that are supposed to be private. People take work calls, pray, change clothes, decompress, and rest in those spaces. The idea that someone could virtually peep into that space, whether through monitoring software, data tracking, or digital surveillance, crosses a line. Convenience should never come at a cost of dignity and consent. For frequent travelers, trust and security matters. Virtual peeping undermines both by normalizing intrusion instead of respecting those boundaries. Privacy should travel with you no matter where you are. So I said I'm kind of in the middle, so I'm waiting to hear a little bit more information. SB 398, so I'm for it and against, I'm in the middle.
You'd fit in well in our Senate sometimes, man.
I want to see more. So SB 398, broad definition, may put everyday users and creators at risk of prosecution for actions that were never meant to harm anyone, ultimately chilling technological development and creative expression without creating clear standards that distinguish harmful conduct. Refine the bill to ensure protection privacy without undermining innovations and free speech. Strong protections against virtual peeping are both necessary and overdue. Criminalizing this conduct is appropriate response to clear violation of privacy and personal dignity. Individuals who use technology to secretly observe, record, or simulate intimate images, such as AI, of others without consent or engaging in harmful behavior that deserves serious legal consequences. However, hint, hint, SB 398 should be carefully tailored to ensure that it targets the bad actors specifically, rather than casting such a wide net that it captures lawful, non-exploitative uses of digital tools, such as like if you want to create a birthday card, and you want to put your significant other on the birthday card and doing a happy dance or something like that. That should be innocent, but this bill cast a wide net. However, should be carefully tailored to ensure that it targets the bad actor specifically rather than casting such a wide net that it captures lawful, non-exploitative uses of digital tools by clearly distinguishing intentional, invasive misconduct from legitimate, creative, educational, or technological activities. Lawmakers can hold offenders accountable while preserving constitutional protection and avoiding unintended consequences for innocent users. Thank you so much for having me.
Any questions for Ms. James? Thank you.
Thank you so much. And I'll be
Cindy
calling you
Battles
Senator
from the
Beal.
People's Agenda.
Good afternoon. We're in afternoon, right? Awesome. Fantastic. First of all, my name is Cindy Battles. I am the Policy Director with the People's Agenda. I would like to thank Leader Hatchett for the work that we have often done together on legislation, and the fact that he was willing to meet with us, and the fact that you've already mentioned that you'll be removing subsection B and D, you'll love to know that that cuts out about 3/4 of my testimony. You're welcome. I do still want to talk a little bit about the fact that we are creating a felony when a 16-year-old uses AI to create an obscene image. And I am not going to sit here and say that the people's agenda is okay with deepfake porn. I think everyone knows that the obvious answer to that question is no. What I am thinking about is 16-year-olds are like 16-year-old boys are. I am a parent. No offense to the men on this panel, but 16-year-old boys are dumb. Okay, you have a tool that will very easily create a naked image, and you're telling a 16-year-old boy whose brain is barely fully formed, certainly not their frontal lobe, that they cannot do that thing. So we have created protections around AI so that we can't regulate AI, even though AI is the one that's making this very easy, and then we're going to go after a 16-year-old boy. So. And not with no intent to distribute, just to have it. So the only other suggestion that I would make, and I know that we've talked about this, is I don't think a 16-year-old child should be charged with a felony for having an image that they created using AI. And if we're going to do something like that, then we definitely need to make it harder to create those images. And honestly, at this point, that's all I've got. And I'm just going to point out, you kind of said it yourself when you said that there's no use for there's no place to use technology for that kind of thing. But yet, again, we're protecting the companies that's making space for that and punishing kids. That's all I have, and I'm open for questions.
I just have one question. On line 70,
Mm-hmm.
it looks like to me, I hear your thing on felony. Would you have the same concern about the 16-year-old having a misdemeanor? Because I think on line 70, Senator Hatchett's bill limits this to a misdemeanor.
So my understanding when we had the meeting is it's a misdemeanor if the person who has it has consent. Am I wrong about that? Okay. Okay.
Any other questions? Thank you, Ms. Battles.
Thank you.
And Mr. Feldman from the Southern Center for Human Rights.
Good afternoon, Chairman and members of the subcommittee. I'm Blake Feldman, and I'm Senior Policy Counsel at the Southern Center for Human Rights. The aspect of the bill as introduced that concerns us at the Southern Center is that the carve-out for teenagers that was just being discussed, the carve-out for teenagers who generate obscene material depicting a minor is narrower than we think that it should be. And this is assuming if subsections B and D are removed, that what is in D2 would be moved to subsection E. So I'm specifically discussing the carve-out that is in lines 65 to 77 of Senate Bill 398. Late last March, when House Bill 171 was before the Senate Judiciary Committee, the Hatchett Amendment, which we were big fans of, was adopted, and it incorporated a very similar carve-out to the one that is in this bill, lines 65 to 77. Essentially, the carve-outs require that the image depicting a minor must not depict a minor who appears to be under the age of 14. The defendant themselves must be a minor. If the defendant distributed the image, whether to apply the carve-out is up to the court's discretion if and only if three things are true. The prosecution agrees to apply the carve-out. The distribution was not for commercial purposes, and the distribution was not intended to harass, intimidate, or embarrass anyone. Our only issue with the carve-out as it appears in Senate Bill 398 is that it includes one more additional requirement, and that is that the image was generated with the consent of a minor, and that's line 69. We would ask the subcommittee to consider striking that prong of the carve-out. As all of you know, but I think it's important to reiterate, the effect of the carve-out is to protect some teenagers by reducing the offense to a misdemeanor. It does not decriminalize the generation of explicit images of minors. And teenagers who do distribute the obscene images would not benefit from the carve-out unless the prosecution and the court determine that it should be applied and those other conditions are satisfied. Broadening the carve-out to protect teenagers from being convicted of a serious felony sex offense in no way condones or excuses the conduct that we're talking about today and we're talking about in Senate Bill 398. It only reduces the offense to a misdemeanor. And plenty of misdemeanors concern really serious conduct that we as a society do not condone and we appreciate as serious conduct. DUIs, vehicular homicide, battery, shoplifting $499 worth of goods from a store. These are a few misdemeanors that nobody condones and are serious. To the extent it was just mentioned briefly that the current version maybe is only contemplating images trained, AI-generated images that are trained off of actual people. So to the extent that a substitute does incorporate images that don't resemble recognizable actual people, the last thing that I would note is that consent of the minor won't be possible if the AI-generated image is not prompted to create a deep fake of an actual minor. So for instance, if a 15-year-old boy prompts an AI tool to generate an explicit image of a 15-year-old girl with features XYZ. So they're not feeding the tool an image of an actual minor, but are feeding it with a text-based description. That teenager, it would be impossible for that teenager to get someone's consent because a natural human being is not being depicted. So we believe that that teenager should also benefit from the carve-out. For these reasons, we had urged line 69, and that's all that I'm discussing is line 69. The requirement that the image be generated with the consent of the minor, that be removed. Thank you, and we'd welcome any questions and the opportunity to work with the author moving forward.
Any questions from the committee? Thank you for your testimony.
Thank you.
Two more speakers or presenters. Mason Rainey from Technology Association of Georgia. Mason, welcome back.
Thank you, Mr. Chairman and members of the committee. I'm Mason Rainey with the Technology Association of Georgia, or TAG. TAG is a membership trade association representing a little over 1,200 technology and tech-enabled companies and organizations throughout the state. First, we want to start out by thanking Leader Hatchett for bringing this important piece of legislation and for his collaboration on this piece and working with us. We've heard from a broad cross-section of members around some language concerns as outlined by the chairman, and our goal is to synthesize that input into one singular constructive set of recommendations. Protecting children is obviously paramount, and we agree that it is vital that this bill passes. Our feedback is focused on ensuring that the bill targets bad actors while preserving the ability of platforms to prevent, detect, and remove the harmful content generated by this CSAM. So we look forward to the continued dialogue and partnership, and thank you all for taking up this important measure.
Any questions from Mason? Thanks, Mason.
Thank you.
And last, Brian Hines with Gacto. I can't help it. Sorry.
I've got some copies for everybody.
Gotcha.
What's the best way to handle it?
If you'd like to present them to the committee, however's best, you give them here. We'll pass them down.
I appreciate it.
Thank you, Brian.
Hi, well, those are getting passed out, I always like to come prepared with something actually to suggest, so it's not just empty words, and because I appreciate this process is difficult. I'm Brian Hines with the Georgia Association of Criminal Defense Lawyers. First, want to say it's as somewhat as an attorney who's worked with the House for the past 5 years. It's a pleasure to actually get a chance to work with you all too. I know I've met you guys quite a few times throughout the years, and especially Leader Hatchett as well. And I first want to say thank you for taking the time to meet with us earlier about this bill and for the suggestions you've made, what you're thinking about changing. I think that'll help it, and it's very much appreciated, the good faith. So the first two prongs in these recommendations are going to be exactly what Leader Hatchett already said, so you can ignore those for right now. And the other ones are going to be fairly pragmatic, and then there's an option at the end. So I would just suggest, and just to give you exactly, again, the lawyer in me, the technical change, obviously moving the Romeo and Juliet to encompass all of the deep fakes regarding the minors, I think would be prong number 3 would be important. Just as a practice guide too, I think it would be helpful on number 4 to actually name the separate crimes. So for example, rather than making this entire statute virtual peeping, have the one individual crime be virtual peeping against an adult, virtual peeping against a minor. It just makes life practicing easier for people. Next would be revised subsection in the crimes. It's simple enough. Now, number 6 is where I want to draw your attention though. So as it stands right now, if a probation is offered, right now, anyone who is convicted of violating this code section is essentially allowed to have what's generally referred as to sex offender light provisions under 42.835B. Now, I think that's a well-meaning provision in this, but I do want to point out too that also encompasses the misdemeanor crime that would have, so if somebody were within that Romeo and Juliet prong, for example, then they would also be swept up in this potentially, which I don't think is the intent, and I think that's something that could be addressed and so for example, the language just be for felony violation of this code section. Because then you're not getting the people who are a little bit more in the innocent capacity with the Romeo and Juliet that we're trying to carve out already. And the last one just is really more of a question, I suppose, too, and it's really up to the committee if you all want to do this and Leader Hatchett. But we were just a little curious as to provisions lines 94 to 96 that say the provisions of subsections B and D, this code section shall not apply to activities of law enforcement and prosecution agencies in the investigation and prosecution of criminal offenses. And I think what's going on is I think this was probably mirrored off of existing statute, and the goal is probably to protect law enforcement and prosecution if they're going to be possessing this for purposes of that. But this crime is broader than that. It encompasses causing the generation of through the artificial intelligence of these images. So maybe it could be more specific and also ideally include defense attorneys for their clients as well. Because I don't think we want, well, that's up to you all, but I don't necessarily need law enforcement prosecution being able to generate these types of materials either. And again, I don't think that's the intent. So we would just put these on your radar, and obviously just want to thank you all for your time, and it's my pleasure to be able to testify first time with you all.
Thanks. Any questions for Brian? Thank you a lot.
Thank you.
Mr. Chairman, do you have any closing comments you'd like to make on this bill?
Briefly.
Okay.
Thank you, Mr. Chairman. Yeah, so I appreciate all the testimony, and like I said earlier, I look forward to working in a collaborative effort to reach a goal that achieves the policy, which is essentially you shouldn't be afraid that your image is going to be used in the way that these images are being used now, and I'm open to continuing to work with those in the audience and hopefully bring you a good substitute in the next week.
Thank you, Chairman. Any questions for the bill sponsor? Hand it back to you. Or if you want me to,
You can adjourn it.
Motion to adjourn?
Second.
Is there a second? All in favor, aye? Opposed? Thank you. Stand adjourned.